You are welcome to yet another episode of HN What's Your Say? The #1 listening show where we discuss real issues with real people like you. We are still featuring R. Kelly, real name Robert Sylvester Kelly, also known as the R&B King. While the outcome of the New York appeal remains undeclared until the judges are done deliberating on what transpired in the recent hearing, the most likely result is a win for the R&B King on all the contested counts. The charges that are currently in contention, as we have mentioned before, the RICO and Mann Act violation counts, as well as the forced labor charges which attorney Jennifer Bonjean did not find worthy of a long fight. And basing on the arguments that were made along with the available evidence, only a malicious judge would deny R. Kelly the opportunity to have these allegations completely scrapped off his charge sheet. After Bonjean's opening brief during the appeal hearing, the state attorney was invited to respond, and just the way she started off could show that she was in fact fumbling with her own allegations against the R&B King. Imagine she started off by mentioning that R. Kelly had a system in place that lured young people into his orbit and then took over their lives. By mentioning this, she was not focusing on the evidence at all. She was in fact deflecting from the arguments attorney Jennifer Bonjean had made, and had started off with the usual mudslinging that we saw in the Surviving R. Kelly documentary. By starting with that statement, she showed no interest of sticking to the facts of the evidence, if any existed. Everything that was said against R. Kelly was more of descriptive allegations, and not clear facts that R. Kelly did this and it was illegal. Because R. Kelly did nothing illegal, all the government can do is create stories that anyone creative enough can come up with about another person. In fact, when she started off with her loose talk about the R&B King, an appeal judge quickly intervened to put her back on track with the agenda of the day, which was to mention the facts and give the appeal judges something off which they can make an informed decision. The appeal judge then asked her to state what evidence the government had to prove that the staff they claim were part of R. Kelly's criminal enterprise actually knew that the women were underage. She started speaking of the late Aaliyah's story and associating her with the other women who came into R. Kelly's life after, and also spoke of a woman who allegedly received Kelly's number from a member of his entourage that is said to have known her to be 16, and then adds that when this same girl was 17, he instructed her to have sex with him at the back of a tour bus and asked her to scream loud such that the driver could hear. Now listen.
What evidence is there in the record that the staff who arranged these things knew that they were underage?
Yes, Your Honor. So in September of 1994, I'll start there with the victim, Addie, who testified. She testified that she was 17. She was invited by Kelly's bouncers to come backstage at a concert in Miami. That was 3 days after Kelly's marriage to Aaliyah, in which he bribed a county official in order to hide or alleviate the consequences of illegal sexual activity, and obviously members of his enterprise arranged for that bribery, and so we're well aware of that illegal sexual activity. A few years later, in 1998, Stephanie, who was the victim named in Racketeering Act 2, was approached at a McDonald's by a member of Kelly's entourage. He asked how old she was. She told him that she was 16. Kelly's associate then gave her Kelly's phone number and said Kelly wanted her to call him. This is the same girl who at 17 was instructed by Kelly to give him oral sex in the backseat of a car and to be vocal and make noise while doing so that Kelly's driver and another individual who were present in the car could hear, which was a obviously deeply humiliating experience for her.
This state attorney didn't seem to understand what she was talking about. She had been asked to prove that R. Kelly's employees knew that these girls who R. Kelly was with were underage. But then she mentions one staff simply giving out a phone number to a 16-year-old, which is not illegal, and another employee, this time a driver, listening in as the now 17-year-old allegedly does it with R. Kelly at the back of the bus. Note that the driver is not the one who knew the girl had been 16 a year before. These are two different employees at different occasions 1 year apart. Meaning, while the member of R. Kelly's entourage could have known that the female was 16, a year later the driver did not necessarily know that she was now 17. And this shows you just how the government thinks they can confuse stories here and there and still win against defendant R. Kelly. Considering the employee who knew that this female was 16 is not the one who was driving to listen to her mourns, It's far-fetched and baseless to imagine that the driver also should have known that this now 17-year-old had been 16 only a year before. And this is what all the government evidence against R. Kelly looks like. All broken and not connecting at some points. And typical of the government, she also adds how this incident should have been humiliating for the woman at the back of the tour bus to win the appeal judge's emotions. And that comes after minutes of making no legal point with her response. She also speaks of yelling a lot as though the employees should have known that the women are actually having sex with R. Kelly whenever they yelled behind closed doors as alleged. There are certainly many reasons why a woman would yell, and it was never in the employee's jurisdiction to ask their boss what he was doing when the women yelled. We therefore cannot base on such fictional and presumptive rumors we cannot prove when coming up with evidence to prove that the employees were a part of the said illegal enterprise which clearly didn't exist. And then the state attorney speaks of another runner, Michael Navarro, who according to her testified that he responded to phone calls from Kelly's girlfriends. And then according to her he recognized that they were very young. What the state attorney needs to know is that while Navarro may have testified that he used to respond to phone calls from R. Kelly's girlfriends, it doesn't necessarily mean that back then he knew they were actually his girlfriends and not just female guests. What people called these women during trial is what they know now and not necessarily what they knew back then. So someone stepping on the podium and saying I would help answer phone calls for Kelly's girlfriends does not necessarily translate to saying I knew that these young women were actually Kelly's girlfriends. So this still does not fit as evidence that R. Kelly's employees who did these things knew that the women were underage, and also that R. Kelly was having intercourse with them. And it's responses like these that leave the state attorney's submission insufficient to convince the appeal court to uphold R. Kelly's wrongful conviction. And then she speaks of Geronda Pace, who she claims interacted with Navarro when she was allegedly 16 years old and being abused by R. Kelly. As though to suggest that she told him she was actually being abused but he ignored. Geronda having interacted with Navarro when she was 16 does not suffice to conclude that Navarro knew she was being abused by R. Kelly if that was the case in the first place. Remember, the only story we have in the trial transcript about Geronda describes a one-time incident of alleged forced labor, and not a long-term relationship that Navarro should have known about. As the appeal court addresses this matter, therefore, they ought to remember that young females being introduced to R. Kelly was not the crime here. And that a staff picking phone calls coming from what he described as young teenagers is not a crime either. We all speak with teenagers, old as we may be, and it's okay. In fact, many of us have taken teenagers out for pizza and ice cream in certain circumstances, and this is not illegal. What would have been illegal is these employees having first-hand knowledge of what was going to happen to a teenager and introducing them to R. Kelly for that purpose. And without this common purpose, it doesn't matter how much of an enterprise the government attempts to prove, it just cannot qualify to be called a criminal enterprise. According to Cuthbert, listening to the government's arguments in relation to the case against R. Kelly will leave you laughing from within. I pity the state attorneys who have had to sound like teenagers when presenting their case that lacks facts and evidence. I am actually very happy the appeal creates an opportunity for judges to listen to a case for the second times when the emotions are no longer heightened. Listening to their case under heightened emotions can be confusing for one to think that these are actual crimes being described. However, when these emotions have ceased, one is able to realize that all the state attorneys are doing is jumble things up and mix touching stories with the name R. Kelly to make him look bad. While they have gotten away with this for so long now, they will not survive this appeal process. There is no doubt R. Kelly is winning this. If you wish to take part in a live interview on this channel discussing any of these topics, let us know by emailing us on sashahnnewsroom@gmail.com for scheduling. That is all we had for you today on HN What's Your Say? To keep updated whenever we post a new video, subscribe to this channel now. Also remember to hit the bell icon and enable notifications. And feel free to share your opinions with us in the comment section below, and let us know if you would like us to publish your views in our next release. We value all our subscribers' opinions.